Welcome and thank you for joining INCLUDEnyc Live. I am Steffany Ruiz, bilingual family educator with INCLUDEnyc, a New York City organization that works with families of children and young adults with disabilities of any type, ages 0 to 26. Today's topic is supplementary security income and the age 18 redetermination process. This is one of the series of live stream presentations that we air out through the school year, every third Thursday of the month at noon. We will keep it under 60 minutes, and we will use a chat box. So if you have questions, please feel free to chat us, and we will do our best to answer them towards the end of the presentation. Today's guest is Michelle Spadafore. Hi, Michelle.
Hi.
Michelle is the project director of the New York Legal Assistance Group's Disability Advocacy Project. This project provides advice, advocacy, and full representation on Social Security appeals, terminations, and overpayments. Michelle was previously a lawyer at the AIDS Center of Queens County, a community-based nonprofit organization that provides services to people living with HIV and AIDS. Her background includes advising clients on Social Security, access to public benefits and health care, fair hearings, and consumer credit issues. Welcome, Michelle.
Hi.
Thank you very much for being here today. So, Michelle, SSI stands for Supplementary Security Income, a program that pays monthly benefits to disabled adults and children with disabilities with limited income and resources. We understand that a child that has been receiving SSI benefits who is turning 18 will go through a process called or known as the age 18 determination process. And this can be very confusing for parents and the young adult itself to navigate the whole steps. Therefore, we're very happy to have you here today to help us understand the process and, be better prepared for us and be better prepared. This brings us to our first question, Michelle. And let's start by what is the age 18 redetermination process?
So the rules for disability for children are very different than the rules for disability for adults. And Social Security finds that a child is an adult at age 18. So if your child has been found disabled as a child, once they hit age 18, everything has to be done all over again under the adult rules. And so a lot of problems can happen at this process because the parents can think that all of the records that are necessary are already at Social Security because they've been getting benefits this whole time period. But you really need to think of it as like a clean slate, and that you're going to need to submit the documents supporting your child's disability all over again at age 18.
Okay, so we understand then that Social Security will review a youth eligibility for the continuation of SSI benefits based on the disability rules for adults. So no longer based on children.
Yes.
Okay, so how and when will families receive this initial notice about starting the age 18 redetermination?
They normally get a notice in the mail, and it'll probably be just before the individual's 18th birthday. Could conceivably be slightly after, but it's normally a little bit before. They could also be called in for an appointment, but I've more often seen that they will get a notice in the mail that says we are now going to be assessing your child to be eligible as an adult, and it might or might not have additional forms attached that need to be submitted at that point.
Great. Okay, so they will receive a notice, and you say before the age 18. So let's say maybe 1, 2, 3 months before, or more than that.
It could be 3 months before, it could be a little bit earlier. It really depends on the local office and how fast that they are able to be processing these cases. One thing that's really important is you need to make sure that your address is updated with Social Security, because these notices could be coming in the mail, going to the wrong address, and benefits are going to stop if that happens. So once your child turns 17, you should make sure to kind of start the ball rolling preparing for this process, and one of the first things to do is make sure Social Security has your correct address.
So we highly advise parents to be proactive and going to the local office, giving them updated information about their home address and anything else?
I would also start requesting records at that point, because once you get the initial notice about disability assessment beginning, you have a pretty small window for those things to happen, and obtaining records can sometimes take many, many months, especially if you need to get specific assessments done. Those could take 6 months or more. Most children are getting 3-year evaluations done, but sometimes those get pushed back and they don't get done. It's really important that you have the most recent 3-year evaluation done. So if that hasn't been done by age 17, you need to make sure that gets scheduled. You need to be requesting, the most recent IEP. and records like if there's any speech and language assessments, IQ testing, anything like that. You don't need the records back to age 2. You need just whatever is the most updated version of each of those things.
Okay, great. So let's say they do not receive the notice from the Social Security Administration office. What steps should or could the family take?
I would go down to the local office for your neighborhood, and I would say, my child's turned 18, I haven't gotten the notice yet, I just want to make sure I'm not missing anything. You could conceivably call the 1-800 number, but the 1-800 doesn't see the same database that the local offices do, so there might be something going on that the 1-800 number might not see. So if you haven't gotten the notice, I would go down to the local office.
To the local office and just report that your child is close to be 18 or that he's already 18, past 18, and that you understand that there will be a reevaluation or redetermination of the benefits. Are there any forms the young adult must complete? And if so, what are these?
Normally the form that they complete is going to talk about activities of daily living. Can they cook, clean, count change? Can they do physical activities? The problems with a lot of these forms, which are tailored to be adult forms and often are tailored a little bit more for physical disability, is that for children who have mental disabilities or mental restrictions or learning disabilities, that the questions on the form aren't going to capture the actual restrictions of your child. And people will just answer the questions that are exactly on the form and they won't think to put anything else. So if after reviewing the form you realize that it isn't talking about a lot of the problems that your child has, there's a part at the end of the form called remarks, and you can add on extra pages at the end too and talk about the restrictions your child has. If you're doing that, you shouldn't think about your child as a child at this point. You should think about your child as an employable adult.
Hard for some parents.
Yeah, but Social Security, when they're adult, is looking at whether or not they could work 40 hours a week in an unsupported environment, without a job coach, without somebody giving them reasonable accommodations, but just 40 hours a week in a regular job. And if they're going to have problems with that, those are the types of things you want to be talking about in the remarks section.
Yes, and I want to emphasize a little bit more on that, because what are from your experience things or information that parents should focus on that isn't self-explanatory on these forms? What are some examples that you encourage parents to do?
So, and this is also going to come into play later when we talk about the initial hearing and what to talk about with the hearing officer. But in these forms, or in an attached letter, you should talk about the restrictions that your child has had in school, but thinking about it in the context of work. So if your child has had a lot of social interaction problems, acts out around other kids, disrespectful to teachers, or has problems interacting with teachers or taking supervision well from teachers, that could be something that you're thinking about. I've seen these problems with my child. How would that work in a job environment? And you would say that they would have problems with coworkers probably, that they'd have problems with supervisors. If your child has a lot of problems focusing in class, they constantly need to be redirected, or they need the explanation repeated to them more than once because they lose
reminders.
Exactly, they lose tasks. They need to be refocused to things. That's something that, in the same way that that's a problem in school, that would be a problem on the job if they're not working in an accommodated environment. So that's another thing you'd want to point out. So you want to think about the types of things that you've seen your child struggle with, or that the teachers have told you that the child struggles with, and then be applying those to how that would be a problem in the work environment. One thing that can be really helpful is to get, if you have a school that has sent your child to do certain kind of job activities with a group that's kind of a work prep group, and they sent them to, work in a nursing home or do something like that as a group with a job coach.
Volunteering?
Yeah, but sometimes they do it with a job coach so that they can kind of get some job skills and they can get better at that type of thing. And they've really struggled. You could have the job coach or whoever it was to write up a bit about how they were on the job and any restrictions they had, any extra help they needed and supports they needed. Because what we're talking about here is, could they do 40 hours a week in an unsupported environment that didn't give them any job accommodations, and they had no job coach, they had no extra help, and if you think that would be a problem, that's really where you want to focus, is talking about what kind of limitations they'd have in that environment.
Great, thank you very much for pointing out specific examples. So a report from a teacher, would that be helpful to submit as well? You're saying a report from the job coach, right? Someone that has been around with your child when doing some kind of job trainings. reports from teachers, psychologists, or any providers that work with your child as well?
Yes, it's important to ask for all of those and start asking for them earlier, right? Because you want to get those kind of lined up in the year between 17 and 18. And you can talk to them about what it's for, too, and explain to them, this is for them looking at them as an adult. So, if they're struggling in class with certain things that might be a problem on the job, you could talk about those things. But they need to know, what the purpose of this is for. And it's really important to get those beforehand because a lot of times on the forms that Social Security sends you, they'll ask you who the medical providers are. Mm-hmm. And if your medical provider is just your pediatrician, and the pediatrician only sees your child when they have a cold or the flu for a checkup, but they don't actually treat them for any of the conditions that are a problem, that's not going to be the most helpful information. And sometimes that's the only information that Social Security will ask for if that's the only information that's put down. So it's important to tell them not only about who your pediatrician is, but anybody that touches your child's life that's going to know about their functional limitations in a work setting.
Okay, great. So recap a little bit of what you said. Important information or documents that parents should be aware of submitting as well with all the forms that Social Security Administration sent them to is the IEP. You said reports from any providers, job coaches, and also, as we know, the schools should be evaluating every child every 3 years, the mandatory 3-year evaluation. So as well, they should submit these results too?
Yes.
Okay.
And IQ testing, if there's any Vineland testing for autistic children, if there's any speech and language testing, any of that kind of thing, if they've had it done repeatedly over the years, so maybe you've got 4 different versions, whatever's the most updated version is the best to submit.
Okay, great. Thank you very much, Michelle. So for those that are found eligible for the continuation of SSI benefits, how will the young adult be notified?
They'll get a notice in the mail after all the forms are filled out and the documents are all submitted, and that notice in the mail will tell them, that notice in the mail will tell them that they have been found to have their disability continue. But I just want to go back one step and say all of these documents that you're submitting at this point aren't actually going to be submitted to Social Security.
They're not?
No.
Okay.
All of the stuff that you've been gathering, right, all the medical records and things like that you've been gathering, when they send you the thing and they say, we're now evaluating you to see if you're disabled as an adult, there's going to be somebody called a disability analyst who works for the Office of Temporary and Disability Assistance, which is actually a state agency. You might get stuff in the mail already if there's somebody in the household with food stamps or Medicaid or public assistance. They run those programs. But the Office of Temporary and Disability Assistance is paid by Social Security to do disability assessments. Okay. So you might get your initial notice in the mail from Social Security, but all your follow-up notices might be coming from the Office of Temporary and Disability Assistance. And that's who you should be submitting all your records to. There should be an analyst, there should be a name and an address and a fax number, and you can submit all your records to that person. Now, it's important when you submit your records to them that you call and follow up a couple days afterwards and make sure that they got everything you sent, because a lot of times things go astray. You have to submit a piece or all of it over again, and you should keep proof of anything you submit. So if you submitted it in person, you need to get it stamped and keep a copy. If you submit it by fax, you want to keep the fax receipt. If you submit it by mail, keep your copy. Mm-hmm. Don't just mail it. Mm-hmm. Keep a copy and send it certified. Not return receipt, just certified.
Just certified. Okay, so it's not that I can go as a parent to the Social Security Administration local office and just submit these documents. I have to make sure that it's to the officer, the disability officer, analyst that is doing it.
You could technically submit them to Social Security. Mm-hmm. The problem with doing that is they are then supposed to take what you've just submitted and go scan it in the back and submit it then through a computerized process to the Office of Temporary and Disability Analyst. Sometimes that happens, and sometimes it doesn't happen.
It can get lost, too.
Exactly.
Okay.
So that's like an extra step between you and the analyst. If you've gotten the name and the address and the phone number of the analyst on the paperwork they're sending you from OTDA, I personally feel like directly submitting it to that analyst is more likely to get there, and you can call the analyst and make sure that they got all the paperwork.
Well, I'm that kind of person. I would rather just do it in myself and make sure that he did get the information or the documents. So we talked about those students or those young adults that are eligible, found eligible. That's the great scenario. That is good. Now let's go to the difficulty ones where from your experience, where can you give us some examples of a young adult that has been found not eligible for continued SSI benefits? Like, what are the reasons? What are the most common cases? What are the most uncommon cases?
So a lot of times we'll see things where people have had a childhood, birth defect, like a heart condition, like something that happened to them when they were very young that over time has improved. And so now they actually maybe have a little bit more restrictions, but they still could probably work. Not maybe at every type of job, but at some type of job. And that's what Social Security is looking at. Like, could you work at some type of job in the national economy? And so they might be found not disabled due to the medical improvement. Then you also have, there's something called the listings, and there's childhood listings and adult listings. And the listings look at all the different medical conditions a person can have, physical, mental, etc. And the listings are different between childhood and adult, and the requirements are different. So there's some things like asthma and ADHD that are easier to meet as a child, that as an adult you have to have much more severe findings to meet those listings. So a lot of people who have asthma and ADHD end up falling off at the age 18. And then the biggest problem, and part of why we're doing this today, is the reason that people will get denied at age 18 is because they didn't get all their records to the analyst. And the analyst only makes a decision on what they have. And like I said before, even though you've been sending, for the past 18 years records to Social Security, you shouldn't assume the analyst has any of those earlier records. You should assume that you're going to need to submit things all over again. And a lot of parents feel like, I know my child is so severely disabled, there's no way that they could deny. They know all the stuff that's been going on with him in his life. But a lot of times the analyst is looking at it from from 18 onwards. They're not looking at the childhood information. So you need to make sure that you submit it again and submit the updated information to that person, so they're actually making a decision based on the actual record.
Very important. Great. So now, if the young adult is deemed not eligible, right, for benefits under the adult disability rules, how will she or he be notified? Will they receive another letter or a call?
So they should get the same type of notice that the person who was granted benefits would get, except for their notice will say, we've determined that you're no longer eligible for benefits, and it'll give like a stop date. That notice is your first point that's truly important on time-wise, because if you want to appeal it and get continued benefits while you're waiting for the appeal, you have only 15 days to ask for that appeal, 15 days from the date of the notice. So on the notice it'll say 10 days, but for every mailing that Social Security sends out, they give you 5 extra days because they know it takes a while for the notice to get to you in the mail. So you'll have basically, from the date on the notice, 15 days to go down to Social Security and ask for reconsideration of the disability cessation, and to ask for continued SSI and Medicaid benefits while you're waiting for the appeal.
2 forms.
2 forms.
Those are different forms.
Yeah.
Okay.
So in the materials that we're going to provide to people at the end, I have 3 sets of things. One is a detailed outline of each step of this process, because it is very complicated and it's a lot to remember. The second is blank versions of each of these types of appeal forms, so people could print them out and use them when they need them. And then the second is examples of real-life examples where the names and information has been redacted, of what kinds of notices people should be looking for in the mail, so that they kind of visually see what those look like. And so that's all in the packet that they're going to get at the end. But the first 2 of those forms in the packet are the reconsideration form and the request for continued benefits form. Now, you can still ask for an appeal. You can ask for the reconsideration within 60 days of the date of the notice. So if it's past the 15 days, don't be dissuaded. You should go and ask for the appeal, but you won't get the continued benefits while you're waiting.
Okay, so let's see, just to see if I got it. I get the letter, or the parent gets the letter, or the young adult gets the letter, he's denied for SSI benefits or the continuation of them as an adult. I should, in 15 days, go to the Social Security office, local office, this is to the local office, and request the continuation of benefits and the reconsideration as well. Okay, in those 15 days. Let's say I didn't find that letter or anything. Can I still go without the letter, or do I need to bring the letter with me where it's stated that he's been denied?
If you haven't gotten the letter, you can go without it, but if you have it, it's better to bring it. Okay. You can also make this request with those forms by fax or by mail. The only problem with that is often they will then go sit on a pile somewhere and not get input into the system right away. And since you only have that very small window to get the continuation of benefits, it can be done retroactively later, but it's better to have them not stopped than to have them stopped and then have to get them turned back on later. So sometimes it's better to go in person. And sometimes they will tell you, well, do you really want these continued benefits? If you're found not disabled later on, then you could have to pay them back. And we're going to talk a little bit about the end about that piece.
Right. Okay, great. Okay, thank you. And again, if I pass those 15 days, I still can appeal this reconsideration, but I will not continue to have. I have 60 days, you said, right?
60
but
days.
I would not get the benefit.
60 days plus 5 days for mailing, actually, so it's 65 days.
Right, thank you. So who makes the decision to continue the eligibility for SSI benefits? You said it was not the local office.
No, it's OTDA. It's the OTDA Analyst, Office of Temporary and Disability Assistance. So you need to make sure that you're not just watching the mail for Social Security notices, that you're watching it for notices from OTDA.
Okay. And I want to go back a little bit as well, and because I've heard, as we receive so many calls of parents where they're invited to go to a doctor's appointment with the Social Security Administration. And I feel that parents struggle a lot with that appointment. So my first question with that would be, can I bring, is it enough to bring information from my own medical doctor that has been seeing my kid for years, or should I attend this? Can I skip this appointment with the SSI doctor?
You shouldn't skip the appointment, and we'll talk a little bit more about why that's important for the continuation of benefits later on. Mm-hmm. But also because, normally if they have sent you for that, it's because they didn't feel they had enough information to make a favorable decision. So the best way to avoid those appointments even being scheduled is to get all your documentation beforehand and ready, and then as soon as this process starts, to send all that to the analyst. If the analyst has enough records from all the different providers, he shouldn't have to send you to a CE appointment the consultative exam appointment. That's at IMA.
Consultative exam is with the doctors from SSI.
Right,
okay.
Social Security's doctors, they send you to IMA. It's a contract agency that does all of these exams. But if you have submitted everything up to that point from the school and from your doctors and everything like that, they shouldn't need to send you for one of these appointments.
Oh, okay.
So that's why it's important to have all that stuff ready to go. But if for some reason you didn't have it all ready, or they felt it wasn't enough, then they might send you for a CE appointment, and you should go. But you shouldn't send your child alone. You should go with your child.
But he's 18 already. Can I go with him into the doctor's office and everything?
Yes.
I should.
The only way that you couldn't go in with him is if your child said, I don't want my mom or dad going with me. Then that is your child's right as an 18-year-old to say, I don't want my mom and dad going in with me. But as long as your child gives consent, you're allowed to go in with your child. And this is important because a lot of children are not very good at talking about symptoms. They're not good at talking about their restrictions. They're not good about talking about things that are going wrong. And sometimes they just aren't very good about describing anything. So you really need to be in there with them and, let them talk a little bit about what's going on. But if you feel like there's holes that need to be filled in what they're discussing, you should absolutely tell the doctor or the psychiatrist or whoever it is the additional information that they need.
And this, again, could be very helpful to bring a list of things that you know that your kid struggles with, that you can imagine that he will have difficulty in a work environment dealing with, right? So the parent will be able to put some information.
Yes, they should be able to talk a little bit. I mean, if it's an IQ test, they won't be able to, because an IQ test will just be judging the child's IQ. But for a psychiatric or for a medical, they'll probably want the child to answer questions first, but they will often let the parent fill in the blanks.
So there will also be different evaluations done. I thought it was only a physical exam from a doctor. Different ones.
It could be, I normally have seen at most 3 types of things, although I know they're technically allowed to do different things. But the 3 types of things that we see mainly are a physical exam, a psychiatric exam, an IQ test. Okay. And those would normally be done separately, but they're often done on the same day. So you would often go in and go back to back and do all of those at the IMA appointment. Okay,
great. So very important, guys, do not miss this doctor's appointment. Okay, great. How long does it take for a hearing to be scheduled with the Office of Temporary and Disability Assistance hearing officer?
So what has happened at this point is you've gone into Social Security and said, I'm appealing now. I do think the disability continues and I'm appealing that denial. They send it to a different part of OTDA. So originally, all of your stuff was being looked at by an analyst at the initial level. And now they're sending it to the hearing office of OTDA. It's not the same as the hearing office that people might think of at 14 Boren. This is a different hearing office that only does these types of hearings.
Okay.
So that hearing will normally get scheduled in about 2 to 3 months from when you ask for it.
Okay, I thought it took longer, 3 to 4 months?
Yeah, I mean, it really depends on the hearing officer and how busy they are, but normally it's pretty fast. It's within a couple of months. But the problem at this point is if you haven't gotten all of the records in at that point to the initial person, and now you've got them and you've collected them, you should make sure that you reach out to the analyst for this hearing and give that person the records. Now, this is a totally different person, right? This isn't the initial person. This is your hearing officer person. And when you get the notice from OTDA that says we're going to schedule your hearing, it's going to be with this person, that's the person you'd reach out to, and that's the person you'd submit the additional paperwork to. Sometimes if you can submit sufficient paperwork to that person at that point, you don't even have to do the hearing. Because maybe the whole problem was just that the initial person didn't have enough paperwork, and that once you get it to the hearing officer, he's like, oh yeah, I see what you're talking about, this is enough paperwork, and then you don't even have to have the hearing, he can just make a decision based on the records.
Okay, great. And what happens during this hearing, Michelle?
So it's very informal, and it kind of feels very...
Who's there? Like, who's present?
Yeah, it feels very strange to people. It feels like they don't even understand afterwards if a hearing happened. You're just in a basic room. There's a table. There's somebody sitting at the table. And that person's the hearing officer. They're not in a robe. They don't look like a judge. They're just a guy in a room.
Okay.
And that's the person who's the hearing officer. The same as with the CE appointments, the consultative exam appointments. You should make sure that you go in with your child. You will probably have to let your child testify. A lot of parents want to testify for their child. You will have to let your child talk first before interrupting. But you should tell the hearing officer afterwards when they're done, I think that I have better insight into a lot of my child's restrictions, and can I tell you more about problems that they have, and then talk about it then. If you're super uncomfortable with your child being in the room when you talk, you can ask if he'd feel comfortable stepping out, because maybe you don't feel comfortable talking about problems your child has in front of your child. And you can ask for that, and as long as your child, because your child's now 18 and he has to give consent for anything. So as long as your child agrees to it, he can step out. If it's okay with them being in the room and you're okay with that, then that's fine. You can just do it there. But this is where what we talked about earlier is very important about having gone through all of the problems that they had in school and maybe on sample job assignments and things like that, and then taking all of those restrictions, the problems with social interaction, then applying that to supervisors, the problems with concentration, and applying that to focusing on job tasks. Each of those things that you're now thinking about, how would these problems in school then have an impact on their ability to do full-time work? And you can talk to the hearing officer about that. If you want to have it written down because you know that your mind's going to go blank, you can do that.
Yes, I always encourage to do that because I'm the kind of person that I'm always wanting to say so many things to my doctor, whoever I'm going to talk, and then I get there and I'm like, I forgot. So I always bring a list of things with me. So at this point, any advice to those young adults that are going to be part of this hearing? Anything that you as a lawyer can encourage them to do? Because at least from my side, of what I would encourage parents to do is have this conversation prior to having the hearing with the officer, kind of preparing the student or the young adult on the type of answers to give. Not to lie, or absolutely not, but just to prepare them on, be conscious of what are the things they have to make sure to mention to the officer.
Yeah, a lot of times what I'll see is when I get these cases after this hearing has happened and it's talking and it's write up about what the kids have said, and it'll say, I, as the hearing officer, asked the child if they could work full-time, no problem, and the child said, yeah, sure, no problem.
Because they're eager. They want to go out to the world. Yeah.
And I think that they don't understand that it would be in an environment that is unsupported, that doesn't have accommodations, that doesn't have a job coach, that doesn't give them the examples of how to do things over and over again if that's what they need. So you really need to talk through with them and say, we're not saying you can't try to work in the future. You can absolutely try to work in the future, and we'd like to help you try to work in the future. But we want you to be able to work in an environment that's going to be supportive for you, that's going to give you the help you need. And what we're talking about right now is not can you do that type of work. What we're talking about right now is can you do work with no help, with nobody there for you, with nobody giving you extra, accommodations, and all you're going to do is work 40 hours a week, every week, not just 1 week, but every week ongoing, with none of those extra helps. And what problems would you have with that? Would you be able to keep your focus? Would you be able to deal with people with no problems? You need to not be thinking about this isn't the scenario where you're thinking about the most optimistic view of the future. This is where you're thinking about actual problems you've had in real life, and would that be a problem if you were trying to work? And you need to talk to the hearing officer about that and not be unrealistic. But we're not saying we don't want you to work at some point. We just want you to work in an appropriate environment that's going to give you the support you need.
And then going back a little bit to what you told us at the beginning, where it's important to have conversations with job coaches that have been involved with your kid, with the teachers, or with any provider. So do you have substantial information to talk and to report to the officer? Okay, so what happens after the hearing?
So after the hearing, you're now waiting for another notice in the mail. And this is going to be a way more detailed notice. It's going to be multiple pages, and it's a write-up from the hearing officer about what happened at the hearing. So first of all, the hearing officer is going to talk about what records they reviewed beforehand. So any of the records that you submitted earlier, or that had been submitted even earlier than that to the analyst, they should talk about what was in the record. Then they're going to talk about what happened at the hearing, about your child's testimony, about your testimony. And then at the end of it, they might say, based on all this, I find that the child is disabled, and the disability continues as an adult. Or they might say, based on all this, I think the child could work, and they'll normally give 3 jobs. And they're jobs that you're like, what are those jobs? I've never heard of those jobs before. It's like napkin folder, bolt sorter, but they are required, if they're denying a person and saying you're no longer disabled as an adult, they're required to give 3 jobs.
Okay.
So if you see those 3 jobs and you're like, are they going to be giving them those jobs? No, they just have to name 3 jobs that they think your child could do despite any restrictions your child might have.
Got it.
This notice, it's a big packet. It's a lot to wade through. But the second you get it, on the front page, it'll say either disability continues or disability doesn't continue. If it says disability doesn't continue, you have 15 days to ask for a hearing with continued benefits.
Okay. Again, same 15 days.
Same 15 days, has to be done again. So technically the same way, you have 60 days to appeal. You always have 60 days to appeal these types of things with Social Security. But if you want the continuation of benefits during this time period, you only have the 15 days, and you need to go and do this request again. Now, this time period is important for 2 different people to know, right? So if you've been timely last time, right, in your first 15 days, and you've been getting continued benefits this whole time,
okay,
you have to ask again.
Oh, I still, even if you already
asked the first time, you have to ask again the second time. So don't just say, oh, we've got continued benefits, we're fine. No, you have to ask the second time.
Okay.
But on the other hand, the first time around, let's say you missed your deadline. You got the appeal in on time within the 60 days, but you missed that 15-day deadline for continued benefits.
I'm not receiving the SSI benefits anymore.
This gives you a second chance.
Okay.
You have a second chance now to ask for it, and even though it had been turned off, it should be turned back on and continued while you're waiting for the hearing. Now, this time period is even more important than the first one, because that first time period, while you're waiting for this hearing, it was let's say 3-4 months, right? Now you're going to be waiting for a judge hearing with Social Security judge. And the judge hearing with a Social Security judge can take 1.5 to 2 years to schedule. So that's a lot longer time to wait without SSI and Medicaid, right?
1.5 and 2 years, and there's nothing that the parent or the family can do to expedite the process? No.
The only way that you can expedite it is if you have a really serious medical condition like certain types of cancer and things like that. Or sometimes, not always, if somebody is facing homelessness or is in a homeless shelter, sometimes they'll expedite it for financial reasons, but not always. A lot of times they say, yeah, a lot of our clients are in this have this problem, too bad, and they won't expedite it. So mostly you're just going to have to get in the queue with everybody else waiting 1.5 to 2 years for these disability hearings.
Yes.
But this is why that 15 days is so important, because if you're waiting for that 1.5 to 2 years with continued benefits, it's a lot less painful than it would be if you have had your benefits stopped. So the 2 things that you would file at this point is you're going to file the same type of continuation of benefits form that you filed originally. It's the same type of form. You just have to file it a second time. And then you're also going to file a request for hearing with an administrative law judge. And that's for you to go see the Social Security judge, which is your second hearing in this whole process.
Great. Michelle, but I forgot to ask you if it was possible for parents to bring a lawyer to that first hearing that they have with the disability officer.
Absolutely, and you don't even need to wait until you know the hearing is scheduled. If you know you've gotten to the point in the process where you're going to have to start this appeal, you can reach out sooner rather than later. Because, like I said before, how sometimes we can submit enough information to that hearing officer that you don't even have to go for the hearing. Well, it's true of an attorney as well. An attorney might meet with you, do an intake, you give them all the documentation, and the attorney might say, did you give all this to the hearing officer yet? No, you didn't. We send it all in, and the hearing officer looks at it, and you don't even have to do the hearing.
Perfect scenario then. That would be great. So good. Okay, so we mentioned about that the hearing by the administrative law judge can take 1.5 years to 2 years. Let's say, unfortunately, the young adult again has been identified not eligible for SSI benefits. They have been receiving for 1.5 years, 2 years benefits. Can they appeal that overpayment?
Yes. So they can do two different things. Firstly, one type of appeal would be to appeal the decision. If they truly feel that, like, I want to keep fighting this, they could appeal the decision to the appeals council. And that's
There's a third instance.
Yeah, but you don't get continued benefits at that stage.
Okay.
And that's a 60-day timeline.
Okay.
But once the judge makes the negative decision, that's when you're going to get a notice in the mail from the Social Security office that says you're overpaid all these benefits that we've been paying you while you were having your hearings, right? So that could be, like you said, at least like up to even 2 years worth of benefits. So at that point, you can ask for a waiver. It's a waiver of overpayment. There's a particular form that you can fill out for that. And normally what a waiver looks at is whether or not you were at fault. Were you at fault in causing the overpayment? You didn't tell Social Security about something, you lied about something. And then also, does what they call recovery defeat the purpose? And what that means is, can you afford to pay it back? Normally for a person who's on SSI, they assume you can't pay it back. Like if you're low enough income to be getting SSI, they assume you can't pay it back. And normally for an 18-year-old, unless they came into money somehow or something, that's going to be kind of an easy piece to meet, is that they can't pay it back. So then what you're looking at instead is, are they at fault? So there's a special provision in what they call the POMS, and I included it in the packet too, this particular provision, that says if you requested this appeal for these continued benefits in good faith, meaning you truly believe that your child was still disabled or your child believed that they had this disability, that as long as the appeal was made in good faith, and it wasn't just like, I'm all better, but I just want to keep getting my benefits, it was actually like, no, I think I do still have restrictions, I'm not trying to do full-time work, etc., then you should be found to be not at fault. And so in this one instance with these continued benefits at age 18, they're looking at, did you do it in good faith, and then that should be presumed to be not at fault, and then can you afford to pay it back? So you should look at that provision, and I'd even attach it if you're submitting a waiver at this point for these benefits, because they need to look at that. The one piece that we talked about earlier about going to consultative exams, going to their doctors, is really important here though, because one of the things they look at when they look at good faith is, did you give them everything that they needed to help make a decision in your case? So that means both your own records, but it also means that if they scheduled you to go to one of their doctors and you didn't go, then they might try to make you pay back the benefits at this point, because they might say, well, you weren't complying and it wasn't good faith. So even if you don't want to go to the doctors, you need to go, because at this point, this is where it becomes very important to say that you've gone and you've done everything you could to comply with their requirements.
Great. Okay, and how is the experience here with like going to this hearing, this type of hearing with the administrative law judge?
It's much different.
Okay.
It's much different than the original one. So the original one, sometimes people have the hearing with the hearing officer for OTDA and they don't even realize they had a hearing. They're just like, I went in a room and there was a guy and we talked about stuff, and they don't even realize the hearing happened until later. Okay. But at the hearing office that's for Social Security, which is the second hearing, that's going to be at what's called OHO. It's the Office of Hearing Operations. It's for Social Security. There's one in every borough, and that's going to be with a judge there. The judge will be wearing a robe. He'll be up behind an elevated platform where he's sitting behind his desk. Everything's going to be taped, audio taped. So there might be a medical expert there that will testify. There'll probably be a vocational expert there to testify. Fewer people end up getting attorneys at the earlier procedure, right? So at the OTDA hearing, more people end up getting attorneys at the Social Security judge hearing, because it's a little bit more daunting and there's a lot more things going on and different experts that could be there that people don't know how to handle. I personally think that If you can win your case earlier and not have to wait that year and a half to go in front of a Social Security judge, it's better. So if you can find somebody to help you earlier, it's better. But if you can't, it's always good to try to find somebody to help you with the judge hearing. But you should not wait until it's scheduled to look for somebody, because it takes a long time to prepare for these cases, to request records, to get everything all worked up. If you want to do a hearing and you want representation, you should be looking for it as early as possible.
Okay, great. And they can contact NYLAG, right?
Okay,
great. Okay, so let's say if benefits are finally granted, right? This is the best scenario. What should parents or the young adults submit to the Social Security Administration local office once they're granted the benefits?
So once you get a decision back, either at the OTDA hearing, you get a decision in the mail saying you're going to be granted benefits, or at the judge hearing, the Social Security judge says he's granting benefits, or even at the very, very initial appointment, if you hadn't had any of these problems and from the very beginning they decided that you should get continued benefits, any of those scenarios where you get granted benefits, you're going to have what they call a PERC appointment. And what it basically means is you have to come in and show that you're financially eligible.
And this appointment is where?
This appointment's at the Social Security office.
The local office where I've always been. Okay.
Yeah. So at this point, we've been talking about disability the whole time. But SSI has two pieces to it. One is that you have to be disability eligible. And so that's what we've been talking about. But once disability is granted, then you have to go in and prove that you're financially eligible. And so that's what you're going to need to prove when you take the child in. Now, before, anybody who's been getting SSI benefits for their child before, they know that all of their income was deemed to the child. So if they were working, they had to talk about their income, their resources, things like that. Once your child turns 18, it's only about their own money. It's not about your money anymore.
About the
child's money. Yeah. So the child now, you need to go in and you need to show that the child is paying his pro rata share of the shelter and of the food.
The what?
So what that means is he needs to pay his portion.
Okay.
So what you're looking at.
Portion of the rent. Okay.
So you're looking at how many people there are in the household. Okay. And this means even little babies. It doesn't just mean people contributing to the household. So if you have a household and it's a mom and her disabled adult now who's 18, and then she lives with her sister who also has kids, you're basically going to count up all the heads in the household, and then divide the shelter amount and the food amount by that amount, and that's how much the child has to pay. So let's say you have a child, and he lives in a home. There's 4 people living in the home, and the rent is $400. His share of the rent would then be $100. That's his pro rata share. But you don't just look at the rent. If you live in city housing, then normally your electricity and heat is included in the rent, and so then it would just be the rent. But if you live in private housing where you also have to pay for gas and electric, then that person would have to pay 1/4 of the gas and 1/4 of the electric.
This is good news for parents. So they have to start asking the young adult to start paying rent, for food, electricity, and
so it's basically what they consider shelter is rent, electric, and heat. If there is any, if there isn't, then it's like gas, right? It's not telephone or TV or any of those things. It's basically just rent, gas, and electric. And then on the other side, it's food. So they have to pay their portion of the food. If they're getting their own SNAP benefits and they're buying their own food separately, they have a special diet or something like that, then they don't have to contribute to the food of their household because they're getting their own food. But if everybody's buying it all together, then they have to pay their portion of the food. And so all of that should be paid directly to the parent. The child at this point should have a bank account that gets their SSI benefit, so they can write a check every month for that shelter payment to the parent. If they've been getting these benefits all this time, right, they should have been doing it the whole time. The second they turn 18, they need to start paying their pro rata share. And if they don't, Social Security is going to give them a 1/3 reduction. So instead of getting $750 SSI, they're going to get $500 SSI. Because Social Security says, we don't need that much SSI if somebody's helping you out.
Right.
You need to be paying your piece.
So you're going to report that. So we have a question from Shelly Bird. What if you take guardianship of the adult child?
If you take guardianship of the adult child, I'm not sure if we're talking about pro rata or not, they'd still have to pay their portion. If you want them to get the full amount of the SSI benefit, they'd still have to pay their portion. I'm not sure if she more means about like interactions with medical providers and things like that. You'd still, want to be involved, but try to be as respectful to your child's needs as possible. You know, once they turn 18, under the law, they're technically an adult. If they're feeling comfortable with you being in the room with them for a doctor's appointment or something, you need to, you know, make sure that they're okay with it before you go in the room with them. But you shouldn't be denied access to any of these things based on whether or not you have guardianship or not of the child. Like, you should be able to go to the hearings, you should be able to go to the other things with them and ask to be able to talk about their restrictions.
Okay, thank you. I hope we respond your question, Shelley. So, just very quick, I have to report this per rata?
Yes.
Okay. To, how do I report it? Like in a writing, or like how do I prove that he really is giving me this money as a parent?
Yeah. So, when you get the notice that the approval has been granted, very soon after that, you'll get a letter from Social Security setting up a time for you to come in to show the financial information. And at that point, you're going to bring in the bank statements,
Okay.
and you're going to bring in proof of how much the rent is for the family, proof of how much the other things, the gas, the electric, all those types of things are for the family. And then if all along they've been getting SSI benefits, you should show the proof of the checks or whatever that they're writing that they're paying that.
Okay.
And it's also good to write up like what we call a living arrangement form. So that would say, you know, I and the child's name am living at this address with this many people, and I'm paying my pro rata share of the rent, which comes out to this much rent, this much gas, this much electric, and this much for food. Okay. And then have both the parent and the child sign it, preferably date it. The earlier it's dated, the better. You know, this is something you can start as soon as they turn 18. Write this up and be putting it out there. And then bring in all the proofs that they've been making the payments they need to make.
Thank you so much. We have another question. Okay, so Shelley just is like following up with her question, and it's meaning that if we have guardianship, are they entitled to SSI?
No. They if you have guardianship, you've arguably proved that they have significant restrictions. But that same proof that you gave to the guardianship judge to show why they needed guardianship has to be submitted to Social Security to prove why they need to continue getting SSI benefits. It's not just like an automatic. It's not just like, well, I've got guardianship, so therefore he's obviously SSI eligible. Okay. The same proof that you had to give to that judge, you need to give to this judge.
Okay, great. We have a question also from Lisa Martin. My son used to get SSI, and I had an overpayment. I have to pay $200 a month for the past 2 years. Can he apply on his own?
I'm not sure what she means. Like, can he apply to have the overpayment removed on his own? Or can he apply for benefits on his own? He can apply for benefits on his own, yes. And he can also, what they do when you're under 18 is they end up a lot of times treating the child and the representative payee, which is normally the parent, as the same person. So any overpayment that happens, they'll treat it as an overpayment belonging, like, your payee didn't do this and therefore you owe us. But as a child, they should be looked at separately, and their fault and their ability to repay should be looked at separately. So if he's an adult now and there's still an overpayment on his record, he can ask for a waiver on that overpayment now, and he should be granted it because he obviously wasn't at fault because he was a child when it had occurred.
Okay.
I just wanted to say, somebody earlier asked about a PowerPoint. There's not a PowerPoint presentation. There's a PDF of materials that will be submitted afterwards.
Okay, and we also, okay, there's a link below. They're telling me there's a link below that you can click and you'll find there more information. We're going to try to answer the last question before I go to the last part of this, because we think that it's very, very important for parents to also know and professionals. Judith asks us, can a youth that does not receive SSI as a child receive as an adult parent income?
I think she means the parent income was too much. Yes. Okay. So yes, but the whole process is different. So not everything you have to submit. Everything you have to submit, everything we talked about submitting, all of that is very similar. And proving disability is similar, but the process itself is different. This process that we're talking about with the 2 chances at the hearing and the continued benefits, that's only an age 18 redetermination process for people who are presently getting SSI as children. So if you are an adult, you go in, you're over 18, and you're not currently getting SSI benefits, you're going to file a new application as an adult, and that process is slightly different. It does go to the OTDA analyst, and you do have to submit all your records to the analyst in the same way, but you wouldn't have the OTDA hearing. You go straight to the ALJ if you were denied, which is the Social Security judge.
Okay.
So the procedure is different. The finding of disability is similar, but the procedure is different.
Okay, great. So I do want to dedicate some time to the famous Section 301. We hear a lot of parents having questions around this. So what is Section 301, Michelle?
So Section 301 benefits are benefits that an individual can keep getting. Like we talked about, they've been getting benefits as a child, and now they're an adult. And they can keep getting those benefits as an adult, even if Social Security finds them not disabled. So you can ask for 301 benefits at any point in the process where Social Security says they're not disabled. You can ask for it at the initial piece. If you actually think, you know what, I do think my child is not disabled, but I want them to keep getting SSI while they're doing additional things. You can ask for it at the second point for the first hearing, right, with the OTDA judge. Or you can ask for it at the third point after the Social Security judge has made a decision. At any of those points, if they say we don't think your child's disabled as an adult, you can ask for 301 benefits if you're in a particular covered program.
Okay, so I was found not eligible for the continuation of SSI benefits, right? But I am part of a program, vocational training program, approved. I can continue to receive SSI benefits, yes?
Yes.
Okay. How can I apply for this?
So
Section 301.
you're going to be applying at each of those stages. When you get that denial letter, you're going to apply through the local office. But the local office doesn't really get 301. They're very rarely asked about 301. And 301 assessments are made at a completely different office than any other office we talked about before. It's like a centralized office. And so a lot of times they'll just like stare at you blankly if you say, I know I'm not disabled, but I want to keep getting SSI and I want 301, and they won't know what you're talking about. So it's important if you've tried and you failed and they aren't understanding what you're asking for, you can reach out to me about it. But it's also just important that you're using the right terminology, that you're saying 301 benefits. You can look online if you Google it, there's more information out there. But basically your child has to be in a particular type of program. Okay. So if they're still in school, they could be getting an IEP still. Okay? And as long as they have an IEP and they're still in school, that in itself, even if they're found not disabled as an adult, should get them continued benefits under 301 until school ends. The other thing they could do is if they get out of school but they engage in something called Access VR or some other type of vocational program, that program will give them what's called an IPE, just to be confusing. And the IPE is Individualized Plan of Employment. And that individualized plan of employment could include even going to a four-year college. If your child wants to go to four-year college out of school, go to Access VR, engage with services at Access VR, make your plan of employment be that you want to go to a four-year college and you want to get whatever type of degree it is, and they can help you with that process. They can help you with books sometimes, things like that. But they can also give you this IPE. So you could get continuing SSI benefits all the way through college while you're finishing things up. Or they might send you for a vocational program, vocational training, something like that. Same thing, as long as you have an IPE through a vocational program that's approved by Social Security, you can keep getting the SSI even if you've been found not disabled.
Wow, amazing. Thank you very much, Michelle. We really appreciate this information. I want to really, really thank you. I could think and I consider that the information provided was very important. We really received a lot of calls from parents asking us questions. It's not easy to navigate, but the way that you presented it really makes it easier to digest.
It's also really important just for parents to think about. Many parents have been being advocates for their child for a very long time, and they've had a lot of interactions with Social Security over time. They've submitted a lot of information, and they feel like Social Security should know what's going on with their kids and that there's no way Social Security doesn't understand how disabled their child is. They should assume that the person that they've been dealing with or anybody that's been looking at the paperwork up to now is not looking at it presently and not looking at any of that information. And they should assume that everything's going to have to get submitted all over again, that it's a clean slate. Because a lot of people with very, very disabled children will get denied because they expect that Social Security has an institutional memory of their child's disability, and that is not accurate.
I like that, institutional memory. Okay, so everyone should have received a digital handout package via email, which includes information relevant to this topic and our contact information as well, Michelle's and myself. For those interested, and I really want to make sure to emphasize on the package that Michelle mentioned, you will find it towards the end of the package. There's a link that will connect you to a document that tells all the steps of the steps that you should follow, as well as the different forms that Michelle mentioned. For those interested in receiving this material in Spanish, please make sure to contact me, Steffany Ruiz, at sruiz@includenyc.org. And please plug in for our next live stream on inclusion programs for District 75 students. Check our website for information about upcoming events. And remember that past topics of live streams are also available here. See you at our next INCLUDEnyc live stream, Real Conversation on Parenting and Disability. Thank you and all, and goodbye. Thank you, Michelle.